Mr. Aditya Sondi and Mr. Saurabh Kirpal, senior advocates, Mr. Abhigya Singh Gupta and his team at Vidhi, and ladies and gentlemen. A very good morning to all of you. I'm very happy to be part of and to be present in today's program relating to launch of the report on Judicial Transparency Index, assessing disclosure of information by the Supreme Court and by the High Courts. The report has been prepared by the Center dealing with justice, access and lowering delays in India, very appropriately called JALDI, an initiative of Vidhi. The mission of Vidhi is, of course, to help make better laws. Thank you, Vidhi, for inviting me to this event and to deliver the keynote address. Before I deliver my address, let me say a word or two about the report. By this report, as you have seen in the presentation, an assessment is being made on the disclosure of information by the Supreme Court and by the High Courts on the scale of Judicial Transparency Index. The report has been processed under three broad categories: the judicial processes, the institutional governance and administration, and judicial and administrative personnel. And each category is further divided into 6 themes. As we go through the report, we will find out the details in which the hard work carried out by the team. The report says, and I fully agree, that transparency in the judiciary is central to the functioning of a constitutional democracy. This is the theme on which the report is prepared. By enabling public oversight and informed engagement, it strengthens judicial independence, fairness and efficiency. A judiciary that commands greater public trust is better placed to enforce governmental accountability and uphold the rule of law. The report notes that the Indian judiciary has taken significant strides towards greater transparency. However, as we have seen and as we go through the report, we'll find much more needs to be done. To encourage greater systemic transparency, JALDI has developed the Judicial Transparency Index in 2025, providing baseline standards against which transparency in Indian courts is assessed, thereby hoping to serve as a valuable resource guide for institutional and external stakeholders to strengthen judicial openness. For the purpose of the Judicial Transparency Index, transparency has been defined as a proactive disclosure of information on court websites that enables the public to assess the court's functioning. By examining the higher judiciary in the light of the Judicial Transparency Index, and at the same time by offering recommendations, the report aims to draw the attention of the stakeholders to those areas which crave for institutional reform. There are significant areas where a lot of work can be carried out, strengthening transparency and foster greater openness in courts. I am sure all the stakeholders will be highly benefited by this timely report, which will be put to effective use. I am sure this report will be a significant addition to the cause of transparency in the Indian justice delivery system. For this commendable exercise, I must compliment Jyotika Randhawa and her entire team at JALDI. Let me not take further names because in the process I may miss out one or two names. Of course, I have to congratulate R.J. Gupta, the founder and research director of Vidhi, and all those associated with Vidhi for the commendable work that they have undertaken. Congratulations. Friends, every legal system that claims to administer justice rather than merely dispense justice must answer an old and uncomfortable question. And the question is, who watches the watchman? That is the question. Let me start my oration by going back to Plato. Long years ago, Plato, the great Greek philosopher, had observed in his treatise, Laws, that citizens should attend and listen attentively to the trials. Hegel, the great German idealist, in his philosophy of rights, he maintained that judicial proceedings must be public, since the aim of the court is to render justice, which is universal to all. Then we come to Jeremy Bentham, because no discussion on transparency is complete or can be initiated without a reference to Bentham. The English philosopher, jurist, and social reformer gave what remains the sharpest answer in the common law tradition. Writing at the birth of the modern rule of law era, he insisted that publicity, the systematic exposure of official conduct to public view and public judgment, is not an incidental virtue of good governance, but its very precondition. Bentham further developed the idea of open justice in the 18th century by declaring that the doors of the public, of all public establishments, ought to be thrown wide open to the body of the curious at large. Highlighting the theory of open justice, Bentham said that judicial proceedings, from the first step to the last inclusive, should be carried out with the utmost degree of publicity possible. The only exception that Bentham would exclude from such proceedings was in-camera proceedings relating to a particular kind of cases, which were to be taken up in the judge's chamber. If you look at Bentham's exposition, we will notice that his insight is not structural, is structural, not sentimental. Law is administered by human beings, and human beings, howsoever well-intentioned, are moved by private as well as public interests. And this is what was reiterated by Ambedkar in the Constituent Assembly debates while dealing with the power of the Chief Justice. Left unchecked, officials, including judges, will sooner or later make what Bentham called the sinister sacrifice, the surrender of the public interest to a private one. Friends, constitutions can entrench rights, legislatures can separate powers, but neither device, Bentham argued, is well executing. What actually disciplines an official is the near certain prospect of being seen, understood, and judged by an informed public. He called this the public opinion tribunal, a tribunal with no formal jurisdiction and no power to punish in law, yet one whose verdicts, through reputation, esteem, and the withdrawal of trust, reach further than any court order. In 1913, the House of Lords in Scott versus Scott declared that open justice is a long established principle of common law. It is a very sound and sacred component of the administration of justice and is placed on a high pedestal in a liberal democracy. Lord Shaw's observation that publicity is in the administration of justice is one of the surest guarantees of judicial integrity, and that the courts sit in public not as a favor to onlookers, but as a structured safeguard of the process itself. This is pertinent. It is classical, yet so contemporary. As recently as in 2010, Lord Judge, the Chief Justice of the Court of Appeal, in Regina Muhammad versus Secretary of State, this was a matter relating to an Ethiopian national who was held in Guantanamo Bay on charges of terrorism. Certain portions of the judicial proceedings were not given to him, redacted, not forwarded, and this was challenged by him in the Court of Appeal. In that context, Lord Judge said he draws a link between open justice and democratic values. He says the principle of open justice represents an element of democratic accountability and a vigorous manifestation of the principle of freedom of expression itself. Ultimately, it supports the rule of law. Transparency is not alien to Indian jurisprudence. By now, open trials and access to the public during hearing of cases before the court has become an accepted norm. If you look at section 153 capital B of the Civil Procedure Code, it says that a place in which any civil court is held for the purpose of trying any suit shall be deemed to be an open court to which the public generally may have access, as far as the same can conveniently accommodate them. However, for good and sufficient reasons, the presiding judge may restrict or regulate such public access. Then you come to section 327 of the Code of Criminal Procedure. It says the place in which any criminal trial is held for the purpose of inquiring into or trying an offence shall be deemed to be an open court to which the public generally may have access, of course subject to the accommodative capacity. However, the presiding judge or magistrate may regulate or restrict such access for good and sufficient reason. An exception to that principle being the inquiry into and trial of rape cases or other related offences, which should be held as far as possible in camera. And it shall also not be lawful for any person to print or publish any matter in relation to such proceedings except with the previous permission of the court. Even if permission is granted, the names and addresses are not to be published, which appears to be in sync with section 228A of the Indian Penal Code. Then we have Article 145(4) of the Constitution of India, which says that no judgment shall be delivered by the Supreme Court save in the open court. Even rendering of opinion under 143 also has to be in terms of this provision. Therefore, the concept of open court in the dispensation of justice is fairly acknowledged within the Indian legal framework. Naresh Sridhar Mirajkar is a 9-judge bench decision of the Supreme Court. Mirajkar was a journalist serving as a reporter of the English weekly Blitz, published from what was then Bombay. At one point of it was a very popular magazine and edited by Rusi Karanjia. One Krishna Raj sued Karanjia before the original side of the Bombay High Court and claimed damages for alleged defamation because of some publication in Blitz. In the course of the trial, one of the witnesses requested the learned judge hearing the suit. He was none other than Justice Tarkunde at that point of time. to protect him by directing that his evidence should not be reported in the press, particularly in the Blitz, because he said the way it was reported, it was harming his business interest. He was suffering loss. The learned judge then told the learned counsel appearing for current year to tell the petitioner, Naresh Sridhar Birajkar, not to publish reports of evidence of the said witness in the Blitz, which he was doing all this while. Now, this was challenged by Birajkar before the division bench of the Bombay High Court in a proceeding under Article 226 of the Constitution, saying that his fundamental right to free speech was being curbed by this order. The writ was dismissed by the division bench on the ground that the impugned order was a judicial order of the High Court and was therefore not amenable to judicial review. He carried forward his challenge to the Supreme Court in a proceeding under Article 32 of the Constitution. It is not necessary for us to delve into the details of the proceedings before the Supreme Court and the different facets of the judgment which followed. What is relevant for our purpose is the observations made by the legendary Justice P.B. Gajendra Gatkar, the then Chief Justice of India, speaking for the bench. This, I think, is of seminal importance. He said, and I quote, in general, all cases brought before the courts, whether civil, criminal, or others, must be heard in open court. Public trial in open court is undoubtedly essential for the healthy, objective, and fair administration of justice. Trial held subject to public scrutiny and gaze naturally acts as a check against judicial caprice and vagaries, and serves as a powerful instrument for creating confidence of the public in the fairness, objectivity, impartiality in the administration of justice. This is 1966. That point of time, Chief Justice Gajendra Gatkar was mentioning about judicial caprice and vagaries, mind you. Public confidence in the administration of justice is of such great importance that there can be no two opinions on the broad proposition that in discharging their functions as judicial tribunals, courts must generally hear causes in the open and must permit the public admission to the courtroom. Chief Justice Gajendra Gatkar quoted with approval what was observed by Bentham and extracted in Scott versus Scott. It is so relevant that I would once again quote what was said. And he says, in the darkness of secrecy, sinister interest and evil in every shape have full swing. Where there is no publicity, there is no justice. Publicity is the very soul of justice. It is the keenest spur to exertion and the surest of all guards against improbity. It keeps the judge himself while trying under trial. By publicity, what is meant is public access to justice and transparency. However, Chief Justice Gajendra Gatkar was quite mindful of the fact that there are some category of cases where the requirement of the administration of justice itself may make it necessary for the court to hold a trial in camera. Barring such exception, the general principle is of open court justice. In his concurring opinion, Justice Hidayatullah also gave a concurring opinion and his quote was there. Justice Bachawat opined that a court of justice is a public forum. It is through publicity that the citizens are convinced that the court renders even-handed justice. It is therefore necessary that the trial should be open to the public and that there should be no restraint on the publication of the report of the court proceedings. The publicity generates public confidence in the administration of justice. In rare and exceptional cases only, the court may hold trial behind closed doors or may forbid publication of the report of its proceedings during pendency of the litigation. Save in exceptional cases, the proceedings being before a court of justice should be open to the public. Friends, there is no doubt that open courts make it possible for the public to develop reasonable perceptions about the judiciary by enabling them to directly observe judicial behavior, the processes and outcome of cases. In fact, the first judge's case, S.P. Gupta, Chief Justice P.N. Bhagwati, drew an interconnection between democracy, transparency and accountability. According to him, an open government does not mean openness only in the functioning of the executive arm of the state. The same openness must characterize the functioning of the judicial apparatus as well, and this includes judicial appointments and transfers. We'll come to this a bit later. The most visible transparency development of the last decade has been the live streaming of court proceedings. The issue before the Supreme Court in Swapnil Tripathi was that important Supreme Court proceedings having an impact on the public should be live streamed in a manner that is easily accessible for public viewing. In that context, Supreme Court held that the right of access to justice flowing from Article 21 or the concept of justice at the doorstep would be meaningful only if the public gets access to the proceedings as would unfold before the courts. The issue was also examined from the perspective of entitlement of the public to witness court proceedings, which is traceable to the right to know and the right to receive information as being a facet of Article 19(1)(a). Live streaming of court proceedings has the potential of throwing up an option to the public to witness live court proceedings, which would result in actualization of the right of access to justice itself. Live streaming of court proceedings, in one sense, is to virtually expand the courtroom beyond the physical four walls of the court hall. Live streaming epitomizes transparency, good governance, and accountability. It would give the viewing public a virtual presence in the courtroom and also educate them about the working of the court. Justice Dr. G.Y. Chandrachud based his concurring opinion on the premise that citizens have a right to know and follow court proceedings. The idea of live streaming of courtroom proceedings has its genesis in the principle of open justice. He referred to Lord Diplock's remark that open courts are a safeguard against judicial arbitrariness and idiosyncrasy. Again, these are not my words. In his view, open courts help build public confidence in the administration of justice. Public confidence in the judiciary and in the process of judicial decision making is crucial for preserving the rule of law and to maintain the stability of social fabric. People's access to the court signifies that the public is willing to have disputes resolved in court and to obey and accept judicial orders. Open courts effectively foster public confidence, allowing the litigants and members of the public to view courtroom proceedings would ensure that judges apply the law in a fair and impartial manner. Then we come to the case of the Central Public Information Officer, Supreme Court of India, versus, I forgot his name, I think it's Agarwal, Subhas Agarwal, yes. It sought to answer, the Constitution bench sought to answer the question how transparent is transparent enough. That's how the Constitution bench framed the question. In the context of the collegium system for appointment and elevation of judges to the Supreme Court and to the High Courts, declaration of assets, etc. The above issue arose when the respondent sought copies of the correspondence exchanged between different constitutional authorities, together with file notings relating to the appointments of Justices H.L. Dattu, A.K. Ganguly and R.M. Lodha, superseding the seniority of Justices A.P. Shah, A.K. Patnaik and V.K. Gupta, Virendra Gupta. Despite directions by the Chief Information Commissioner, the appellant, that is the Central Public Information Officer, Supreme Court, declined to provide the information sought for on the ground that Registry of the Supreme Court does not deal with matters pertaining to appointment of judges, as appointment of judges to the higher judiciary are made by the President of India according to the procedure prescribed by law. The Constitution bench, speaking to Justice Khanna, emphasized on the need to balance fundamental right to information, which is traceable to free speech and expression on the one hand, and the independence of the judiciary forming part of the basic structure of the Constitution on the other hand. Observing that judicial independence and accountability go hand in hand, the bench was of the view that transparency and openness in judicial appointments, juxtaposed with confidentiality of deliberation, remain one of the most delicate and complex areas. The judgment notes that the position is progressive as well as evolving, as steps have been taken to make the selection and appointment process more transparent and open. Dismissing the appeal, the bench held that the office of the Chief Justice of India is a public authority within the meaning of the Right to Information Act, bringing judicial appointments correspondence within its reach, albeit qualified by considerations of confidentiality and public interest. It permitted disclosure of assets by judges. I have also disclosed my assets, whatever little it's there in the public domain. In a supplementary opinion, Justice D.Y. Chandrachud holds that disclosure of assets of judges is warranted in the larger public interest. The argument that independence of the judiciary would be affected prejudicially due to disclosure of such information is specifically rejected, as it cannot be argued that information regarding the assets of the judges who are public functionaries is personal information having no relationship with any public activity or interest. In this regard, he emphasized that the edifice of judicial independence is built on the constitutional safeguards to guard against interference by the legislature and by the executive. Judicial independence is not secured by the secrecy of the cloistered halls. Again, not my words. It cannot be said that increase in transparency would threaten judicial independence. He also said that judicial independence cannot be used as a byword for avoiding accountability. Important it is. Judicial independence cannot be used as a byword for avoiding accountability and criticism that accompanies transparency. Accountability and transparency are not only necessary for upholding the democratic underpinnings of the Constitution, but are also necessary for the independence of the judiciary itself. Both are mutually reinforcing principles. The most instructive recent development for a lecture grounded in Bentham is the Supreme Court's own mid-2026 intervention. It has come very recently, restricting unauthorized clippings, editing, and circulation of live streamed proceedings. While according to one view, the court's concern is precisely the one Bentham anticipated, that decontextualized fragments of oral exchanges, observations made by judges in the course of arguments, not findings, are being circulated with sensational captions, causing reputational harm to judges, advocates, and the litigants alike, and distorting public understanding of what had actually happened in court. According to this view, there is a counter view also. The order does not retreat from live streaming. It draws a distinction, familiar from Bentham's own writing on the necessary limits of publicity in adjudication, between transparency of the process and a license to manufacture a misleading narrative from the process. Friends, all said and done, Vidhi has done a commendable job for which it deserves all appreciation. But I believe there is always room for improvement. While carrying out the next assessment on the scale of Judicial Transparency Index, I may request the JALDI team to also look into the aspect of opacity of the collegium system. Deliberations over the elevation and transfer of judges remain confidential. Reasons for rejecting or deferring a recommendation are rarely disclosed in full, and the criteria applied are not codified in any publicly accessible instrument comparable to the Memorandum of Procedure's own limited disclosure. I have seen that the last three statements of the Collegium, Supreme Court Collegium, I have with me those three, 2025 and the last one, do not contain any reason at all for recommending elevation as opposed to the earlier statements, where each of the recommendations were supported by some reason. May not be full, some may say these are all copy-paste kind of reasons, it's okay. But at least some reasons were given to justify the recommendations. But I have noticed the last three recommendations of the Collegium do not contain any reason at all. Is it going back on the transparency principle? These are important issues. Citizens, as we have seen, right from Plato to Bentham, have a right to know what is happening in the courts. They have a right to know who would be their judges. They have a right to know what kind of judgments the Honorable Judge has delivered. This should be in public domain. We find that previous, at least 2-3 Collegium recommendations I find were very, very elaborate. One recommendation I find during Chief Justice Lalit's tenure, where it did not fructify, but reasons have been given. Good reasons have been given. One Collegium resolution I find is of 18/1/2023, where the Supreme Court Collegium reiterated the recommendation of Solve. That was 18 January 2023. It's nice. I would say the reasons given by the Supreme Court is quite convincing. At least I'm convinced by that reasoning. It is another matter that 3.5 years have gone by, nothing has happened thereafter. That's again another debate, not part of this conversation. We'll have some other debate some other time. I have recently come from Bhopal after one of the speeches. I believe after retirement, we should have a cooling off period I think after one of these speeches also there should be some cooling off period. These are important areas which I think should be looked into. This we may call the reflexive gap. A judiciary that has embraced publicity in its adjudicative function has been markedly more cautious about extending the same principle to its own constitutive process. I am sure we'll have a very enriching panel discussion hereafter. Thank you very much and God bless.